Good morning. My name is Isabel Costa Carvalho. I'm the office managing partner of Hogan Lovells, São Paulo. And it's my pleasure to welcome you to today's presentation on an interesting topic in the context of financing transactions in Brazil. When Eduardo Salomão approached me to discuss holding this webinar, I thought it was a great idea. As an international firm, based in Brazil, we often work on cross-border matters and see the effects of the market perception on Brazil. We have a new government since January, and with it, we have been facing new discussions on tax reform, the role of Brazil, the government in the economy, its views on environmental matters and funding, the role of Brazil in the global economy, with the agribusiness helping the results the first semester, but also with large companies facing financial distress. Americanas in the consumer sector, light in electricity, and the global scenario has not been calm either, with the banking sector facing problems caused by failures in the US, with banks in California and Credit Suisse Credit Suisse has business in Brazil, and coupled with the continued war in the Ukraine. So we have seen investors taking a cautious approach on Brazil, which often causes financings to be more constrained, unless transaction provides safeguards. In this context, discussing various aspects of creating security over Brazilian assets becomes very topical. The focus of today's presentation will be on legal solutions available to grant or obtain financings in the current scenario, with the benefit of first listening to our distinguished guest, Dr. Maílson da Nóbrega, on his views on the economic scenario in Brazil. Before moving on to the presentation, I'm delighted to introduce my fellow speakers who will be presenting today. So first, it's a pleasure to have Dr. Maílson da Nóbrega as one of our speakers today. As I'm sure most everyone listening here today knows, he's a prominent economist and the former finance minister of Brazil. Dr. Maílson has been and continues to be a very important figure in the economic and financial development of Brazil. He oversaw the Brazilian economy during some very challenging times in the late 80s, with his focus on financial responsibility and the pursuit of economic stability were critical in fighting hyperinflation and navigating a difficult economic scenario then. In addition to his tenure as finance minister of Brazil, he had a long career working at Banco do Brasil, as well as focusing on the public sector. He has had a distinguished career in academics and is a consultant on various aspects of economic and fiscal policy. He is currently a partner of Tendências Consultoria Integrada, where he provides economic consulting to companies, law firms, and business organizations in all sectors of the economy. And he has also published a number of influential books and is high demand as speaker. So we are very pleased to have him today. Second, we have Eduardo Salomão, who is one of the founding partners of Levy Salomão, one of the premier law firms in Brazil. Levy Salomão is a highly respected law firm, and we frequently work together on a variety of cross-border transactions, and we highly recommend them to our clients due to their innovative and practical solutions. Eduardo is one of the most respected banking lawyers in Brazil. His practice includes a focus on domestic international banking operations, including syndicated loans, project finance, securitization, complex guarantee structures, and capital markets transactions. He's also a professor and frequently speaks at conferences and webinars. He's accompanied by his partner, Roberto de Assis, who also has a practice focused on structuring and negotiation of international lending and finance transactions, and with whom we have also worked very often. He has extensive experience in foreign financing transactions involving capital markets financing, single bank finance, syndicated loans, club deals, project finance, and structured finance. He advises a wide range, an array of clients, including multinational corporations, financial institutions, and domestic companies. He has also worked for 10 years in the legal department of Deutsche Bank in Europe, so he brings his unique perspective on having worked at a financial institutions as well in private practice. Last but not least, my colleague, David Tyler, he has been working with me for almost 15 years, has been engaged in a diverse corporate and finance practice for over 20 years, with a particular emphasis on structured capital markets and finance transactions originating from Brazil. He represents companies, banks, sponsors, shareholders in a number of different product areas, including structured finance transactions, project bonds, liability management transactions, and also debt and equity transactions. And he recently relocated to São Paulo from the Hogan Lovells office in New York. So today we'll begin with Dr. Maílson, who will provide us with an overview of the current economic scenario in Brazil and discuss various issues relating to future prospects of financing transactions in Brazil. My colleague David will then discuss certain aspects of international finance transactions involving the use of Brazilian assets, including an overview of the type of transactions where issues regarding Brazilian collateral in the context of finance transactions are important. Next, Luiz will discuss the process of providing Brazilian collateral in the same context and various related aspects of it. And finally, Eduardo will discuss if it's possible to overcome current challenges faced by Brazilian companies in obtaining financing from international sources and the prospect of having Brazilian companies be the recipient of financing. Questions will be left for the end, but you can send along during the presentation. There's a button at the bottom of your screen, so you can type it along and we'll look at it. And at the end, we will allocate to one of our speakers. Thank you all again for being here, and I'll pass on to Dr. Maílson. It's on mute, Dr. Maílson.
Sorry about. I'm not used to technology. Sorry. Well, good morning for everybody. It's a pleasure for me to be here, and I would like to start thanking my old friend Eduardo and Isabel and the other members of this group for the invitation to speak to you about the prospect of the Brazilian economy. I would like to say that at the end of my presentation, I'll be available for questions because I have to leave before the end of the event, right? If it's possible. Is that right, Isabel?
Yes, of course.
Okay.
Yes.
Let me share the presentation. Let me see where it is. Just a moment. Wow. Just a moment. I'm not finding the presentation. It vanished from my screen. I'll find it. Did you see the presentation?
Yes.
Okay. Well, Brazil has two most pressing challenges. The first one, sorry. The first one is a risky fiscal environment that is caused by low budget flexibility 5 major expenditures, pensions, the personal role, education, health, social programs account for more than 90% of primary spending in Brazil, and it may worsen in coming years, right? That remains just 10% of budget for the government to conduct policies designed to improve growth, reduce inequality, and so on. It's the Achilles heel of Brazilian economy, the fiscal situation. Then, debt to GDP should reach 90% in the next 5 years. It is now around 75%, one of the highest in the emerging market countries, right? And it means that if this situation is not tackled properly, we may run a risk of a public debt crisis in years ahead. And the second challenge is, low productivity. Industrial productivity has stagnated in the past 20 years. Just agriculture, the champion of Brazilian economy at this moment, is the only sector with significant productive gains. The agricultural sector has been improving its productivity at a rate of 3 or 4% a year. And because of low productivity, fiscal risks, Brazil has been caught in a low growth trap. We are growing around 1 to 2% a year, and the potential for the Brazilian economy to grow is today, according to some economists, around 1.5% only. Right? How to deal with that? Reforms, right? That's a general perception that Brazil needs bold reforms to be rid of these challenges. Again, fiscal situation and low productivity. On the fiscal side, we need to restructuring mandatory spending. It is very much needed for Brazil to recover the flexibility in managing the budget, right? The second, administrative reform. Administrative reform, the main focus of this reform, which is now being discussed in Congress, is to improve quality of public sector, the way the public sector serves society and the economy, and probably some reduction of payroll costs. Unfortunately, those reforms cannot take place with current government, right? Because it will require not only leadership and political will, but the support of society and the ability to mobilize Congress in favor of these so complex reforms. Other fields, tax reform. The tax reform can be divided in 2 fields. The first one is to deal with the chaos that characterize the consumption tax in Brazil. It's a very chaos. It is a system comprised of 5 different taxes, each different of one, taxing cascade, uncertainties, for a state tax that change 7 times a week in all 27 states of Brazil, a real problem for Brazilian economy. And the second camp is to reform the income tax, to deal with privilege that still characterize the taxation of income in Brazil. In my view, tax reform will be approved. It will be a major fact in the Brazilian economy. It's going to be a revolution, in my view, in the way tax and consumption are collected. It is going to be characterized by a modern TVA, VAT, one of the most modern VAT in the world. It is a system that is totally operated by digital technology. All the obligation will be fulfilled just when 2 or 3 touch in a computer. And my perception is that the reform, despite some exception that Congress has been accepting, it's going to be approved around October, November. And we will experiment a long transition of around 10 years to be fully implemented, because it's not easy to migrate from the chaos to normality overnight, right? It will require adjustment on the part of the states, on the part of federal government, on the part of taxpayer to implement this major reform in Brazil. In my view, the most important reform since the end of military regime, structural reform, right? With the support of population, support of society, opinion makers, etc. Another source of reform that could improve the Brazilian situation, the economic situation, would be large-scale privatization. We still have some giant state-owned companies like Banco do Brasil, like Petrobras, who are operated by the central government, despite the fact that they admit private shareholders, right? But I don't see in this present administration political will, courage, and leadership to go ahead with this reform. On the contrary, President Lula decided to suspend all the process regarding privatization of some minor companies, not these two, the one I mentioned here, Banco do Brasil and Petrobras. So I think that if those challenges that I mentioned a few moments ago will not be addressed, then Brazil may face a very complicated situation that could be a crisis of public debt, right? The question is, what happens if this crisis comes in a matter of years? It may overcome, depending on the next government mainly, but suppose that this comes right away. What would happen in Brazil? I think that Brazil is prepared to navigate on this crisis due to the aspect that I'm going to mention to you. First of all, resilience of the economy in the institutional field. Brazil has now a consolidated democracy. We have completing now 30 years of political stability. And our democratic institution resisted many attacks that it suffered from members of the former administration led by President Jair Bolsonaro. We have an independent judicial system, independent investigation of corruption, independent central bank, a situation that was decided recently by Congress and has been very important at the present moment when Lula decided to attack the central bank governor for the high basic interest rate. The press, the Brazilian press, is free, competitive, and aggressive. It was a statement by the Economist some 2 or 3 years ago, right? I would say that Brazilian press is similar in terms of independence, quality, courage, similar to that of the rich world. Right? Market discipline. Market discipline means the government reacts when the market judges negatively action by the government. It has been worked quite well in Brazil over the last years. And the poor vote. The poor, I mean the illiterate. Until 1985, illiterate people were not entitled to vote in Brazil. This came to an end at that year, and now everybody in Brazil can vote, right? And this franchise was extended to illiterates in 1985. And new beliefs in society. To those who read the famous book of Douglas Norman, an American historian and economist, Nobel Prize of Economy, who died recently, Mr. Norman said that beliefs is the main source of building up institution. Douglas North, that's his name. Sorry for the mistake, right? And we have seen two new beliefs that appeared in Brazilian society over the last 40 years. The first, intolerance to inflation, that is highest among the poor. Until, say, 40 years ago, we Brazilians thought that inflation had a role in the process of development as a type of combustible for growth. No longer the case. After hyperinflation, the Brazilian society learned to hate inflation, and this hate is higher in lower level of the Brazilian society. The second is intolerance to corruption. Until recently, say 10, 15 years ago, we Brazilians thought that corruption is a fact of the political system. We may have to deal with that. It's common. It's not acceptable, but it happens. That's no longer the case, right? After the Lava Jato or car wash operation, when important figures of the political scenario and the business scenario went to jail, and society woke up for the idea that corruption is bad for the Brazilian economy, is bad for the Brazilian society. We have many examples when politicians who are sentenced to jail, they lost all the capacity to run for election in Brazil. And on the field of the economy, we have also big demonstration of the resilience of the Brazilian economy. First, agriculture and mining sectors are very competitive. Agriculture is the star of the Brazilian economy. To have an idea, this year, the GDP of the Brazilian agriculture will be larger than the total GDP of Argentina, right? The Brazilian, it is a success of technology. That's a process started some 50 years ago, right? And Brazil became a power in agriculture in the world. At this moment, Brazil is number 3 as an exporter of agricultural product. In number 1 in certain items. For instance, number 1 in sugar, number 1 in coffee, number 1 in meat, number 1 in poultry, corn. This year, Brazil will overtake the United States as the largest exporter of cotton. We are number 1 in orange juice, number 1 in cellulose, number 1 in 9. I may have forgotten some of them, but 9 products. Brazil is number 1 in export of agricultural product. And in view of that, there was a structural change in the Brazilian balance of payment. Brazil became a larger exporter. Brazil has surplus in the trade balance due to exports of agriculture and products from the mining sectors. And because of that as well, Brazil became international creditor. Brazil has more international reserves than its debt, external debt. The international reserves account today for $340 billion, while the foreign debt of the public sector is only $70 billion. In other words, we have international reserve that accounts for 5 times the foreign debt of the public sector in Brazil. Another feature of the Brazilian economy over the last 20 to 40 years is the lack of vulnerabilities of the past. Crises in Brazil normally took place due to banking crisis or crisis in balance of payment when Brazil was forced to suspend the payments of obligations abroad. Right? It's no longer the case. Brazil has today a financial system which is solid, sophisticated, and well regulated. The Central Bank of Brazil became a high-quality regulator, and the two last governors of the central bank were considered #1 central bank governor by the world community, right? Attesting their competence and commitment to regulate very well the financial system. The last banking crisis that took place in Brazil was in 1995, almost 30 years. And Brazil, let me repeat, the central bank is a very high quality regulator. And also healthy external accounts, as I mentioned to you. Crisis of balance of payment had gone in Brazil, right? The latest one took place in 1999. And Brazil is today more able to face crises in the external side. Brazil has 7 of the 10 best universities in Latin America. And let me show here some companies that I have selected, not by a scientific study, but my own experience. I have been member of the board of some of them. I selected 16 Brazilian companies of high quality, right? Embraer, for instance, the aircraft companies. Embraer became last year #1 in passenger jet of 150 seats. And in this year, Embraer with private jet Phenom will be the jet with more takeoffs and landing in the United States. Embraer will overtake Cessna as the most important private jet in the United States. Vale is a mining company, which is the 5th in the world. WEG is a company that produces motors. It's a multinational present in the 5 continents. Anyway, I could mention all of them, but I have no time for that. Just to say that we have some companies of high class, all of them set up before hyperinflation in Brazil, before 40 years ago, and why they are alive until today. First of all, because they are well managed. Second, because they have links with international markets and world trade market. Fourth, because they manage very well their talents, and they are very well capitalized, and most of them are listed in the Brazilian stock exchange. So, if we consider all that, if we consider the risk, even if it comes, Brazil has institutions and companies able to face the risk. As a final remark, some small points that fiscal risk may be reduced in coming years. It's going to depend on political will and political leadership. The consensus is present in Brazil amongst opinion makers, economists, that we must go with bold reforms in the fiscal risk, mainly to reduce the rigidity that characterizes the system at this moment. Second, in the best scenario, they could even be totally overcome in a matter of 10 to 20 years, right? And finally, because of all that, it is foreseeable that finance will flow to Brazil, mainly through capital markets in the coming years, unless substantial economic change take place. Just a point that I'd like to raise. Capital market in Brazil became also very sophisticated. Capital market is today the most important source of long-term financing. And capital markets comprise today 43% of the total credit provided by the financial system to Brazilian companies. That is the presentation. I'm ready to answer questions that we may like to ask. Thank you very much.
Thank you very much, Dr. Maílson. I would like to remind that questions can be made on the Q&A. There is a button in the bottom of the screen where you can type any questions that you may have. I believe the presentation was so clear that there have been no doubts, but
Who would argue with Minister Maílson?
There's
Well, thank you
something
very
I
much.
say in my presentation. When there is no question, there are just two explanations for that. First one, nobody understood anything. The second one, everybody's understood everything, so questions are not needed.
of course we are in case B, option 2 here.
A very clear and clear-sighted presentation, by the way.
Thank you very much.
Thank you. So I think I would be next. So let me see if I can share my screen. Give me one
Dr. Maílson is free to stay as long as he can, but we know that he may have to leave later, but please stay as long as you can and want. Thank you very much.
Yes, Luiz. Unfortunately, I have another call to participate, and unfortunately, I have to leave. Thank you very much again for the invitation. I wish you success in the remaining part of the event. Bye-bye.
Thank you. And sorry for having interrupted you, David. Please.
No, of course. Right, let me see if I can share my screen here, just to make things a little easier. Okay. Can you see my screen? It's hard to.
Yes.
Okay, great. So I appreciate the opportunity to speak to all of you today and what I find to be a very interesting and somewhat timely topic. So I'll be speaking about the US and international perspective of things. So from our perspective, lenders and market participants are accustomed to some level of certainty when it comes to taking security interest in collateral. For example, in the US, we have the Uniform Commercial Code, the UCC, that governs various aspects of security interests. These uniform statutory provisions adopted by various US states govern security interests in all sorts of assets, including tangible assets, intangible assets as well. By tangible assets, I mean physical assets that can be used as part of a company's operations and business, property, equipment, inventory, securities, cash, things of that nature. By intangible assets, we're primarily talking about things such as intellectual property and goodwill. Just looking at things from the perspective of a non-Brazilian creditor or investor, taking security in Brazilian assets, so be it ownership interests in companies or other physical assets, comes with some level of uncertainty, as the process can be somewhat different than what they're accustomed to. Which is why the subject matter to be discussed by Luiz right after me should be of particular interest to everyone on the call here. So, lenders and participants in transactions where security is taken over Brazilian assets, what they want to know is the mechanisms for taking collateral, and I guess perhaps more importantly, remedies and how to enforce against that collateral. Switch here. So, particular concerns include, what are the risks when it comes to taking security over assets in Brazil? So, legal risks, and others such as political risk, change in law is always something that can be a concern. Here the concerns are the perfection and priority of interests in the security. This is why having experienced counsel like Luiz and Eduardo and their colleagues to provide guidance and structuring advice is essential anytime we setting up any transaction. Timing issues. So the process of taking security in Brazil includes a number of formalities, which can take some time. There could be significantly more formalities than others might experience in some other jurisdictions. Registering documents with various authorities, powers of attorney, legally attested translations, things of that nature. Costs. While not typically a huge cost in terms of the overall transaction costs, it's something we get asked about with some frequency. So, today I wanted to briefly discuss a few examples of the types of transactions where Brazilian collateral issues can arise. Obviously, it can come up in a lot of other different contexts, but for purposes of today's discussion, I wanted to highlight a few key areas. The first being lending, a second point being acquisition finance, and then I'll discuss a few certain types of capital markets transactions, which I think would be relevant here. These transactions don't necessarily need to involve an influx of capital or resources to borrowers in Brazil. The key is that the assets are in Brazil that can be used as part of a requisite collateral package for purposes of the financing in question. And it's also worth mentioning concerns that arise in a debt restructuring or insolvency scenario, which can become a stress case on the enforcement against collateral. So, one category of transaction where collateral issues arise are in loan transactions, specifically in secured loans where the borrower grants security to the lender or lendors over a collateral package, which can include tangible or intangible assets. In many instances, this includes granting a security interest over ownership interests in a Brazilian company, which can be a subsidiary of the borrower. There are a number of reasons for taking collateral, include, among other things, for purposes of enforcing on the collateral in the event of a default on the loan in question, to obtain a secured creditor status in the event of an insolvency or bankruptcy of the borrower, and to limit what the borrower or grantor can do with the collateral. So in other words, preventing collateral from being disposed of so that it's available to be enforced upon in the event of a default. Taking security also provides lenders with some control over the restructuring of the borrower's debt, since they'd have the right to foreclose on the collateral, and require the grantors to repay the loans. There are numerous types of categories of lending transactions that could be discussed here, in addition to secured loans, such as, say, asset-based lending. I'll touch on that in a capital markets context in a bit. But in the context of secured loans, what we've seen a fair amount of is companies outside of Brazil pledging assets in Brazil in connection with a lending transaction executed outside of Brazil. It could be New York law or English law governed documentation. Companies that have operations in Brazil include those assets as part of the collateral package in connection with receiving the financing. These can be loans to finance operations, increase capital expenditures, and in certain instances, finance acquisitions. There doesn't necessarily need to be a nexus to Brazil in connection with the transaction, other than having some or all the collateral in question being located in Brazil. Whether it's physical property, equipment, ownership interests in subsidiaries. So a secured lender in the U.S. entering into a transaction with foreign borrowers, it needs to comply with provisions of the Uniform Commercial Code, the UCC, in order to perfect its interests in the assets of such borrowers. Perfecting a security interest in this context provides notice to the perfected party has a valid security interest in the property, and that no other lender can assert the same rights in the collateral. So with respect to the property, filing a UCC-1 financing statement is done to perfect the security interest by providing notice of such security interest. UCC 9301 provides that the location of the obligor determines the venue for filing the UCC-1 financing statements. UCC section 9307 contains the rules for determining the location of the obligor for these purposes, based on its location, its jurisdiction of formation, its place of business. So for obligors formed in the United States that are not formed in the United States, and do not have a place of business or chief executive office in the US, the filing venue would be Washington, D.C. When it comes to accounts such as deposit accounts, perfection can be established through control over the account or the accounts in question, which can be done by agreement, such as a control agreement. It's important to note that there are enforcement risks and conflicts of laws issues when it comes to foreign collateral, the location of the collateral. So in this case, Brazil is the key consideration when it comes to enforcing against that collateral. So where Brazilian law considerations and the Brazilian courts might need to be utilized to enforce against the collateral. So a second set of transactions worth discussing here are acquisition finance. What we see in many instances is the use of secured loans to finance acquisitions. Lenders may require a comprehensive security and guarantee package from the borrower and related parties. As with other types of transactions that involve collateral, the collateral protects the lenders in the event of the borrower's failure to repay the financing. In terms of financing structures used in acquisitions, one worth noting are leveraged buyouts. This refers to the financial strategy in which a company, which typically is a private equity firm, acquires another company using a significant amount of borrowed funds or debt. The acquiring company or the sponsor uses the assets of the target company being acquired as collateral for the loans used to finance the purchase. So in the context of today's discussion, this could include assets located in Brazil, whether they are the totality of the company's assets being acquired, or some component of that company's assets. So the sponsor's goal here is to improve the target company's operations, reduce costs, and enhance its overall financial performance. The idea is that these improvements will eventually increase the company's value over time, allowing the sponsor to eventually sell under the right market conditions. So while private equity firms are typically the ones using these financial solutions, other types of buyers, such as individual investors, strategic corporate buyers, and even management teams can also use leveraged buyouts to secure the requisite financing. Just quickly, some key features of leveraged buyout include, the majority of the funds to acquire the target company come from borrowed money, often in the form of loans or bonds. The assets and cash flows of the target company are a significant component of securing this debt. The acquiring company contributes a relatively small amount of its capital, equity, to the transaction. The idea is to use debt to magnify any potential return on the investment. After acquiring the target company, the sponsor's management team aims to implement various operational changes to increase efficiency, reduce costs, and enhance profitability, with the idea of the ultimate goal of the sponsors to exit the investment by selling the target, ideally at a higher valuation than what it purchased the company. The benefits to this sort of transaction is the ability to generate significant returns on investment, if they're able to implement the operational improvements and the company's value increases. However, obviously there's a lot of risk involved when you take on high levels of debt, as the interest payments can be substantial and impact the financial stability of the acquired company. So another context where we see Brazilian collateral are in the issuances of debt securities. So we have secured bonds. A secured bond is a debt instrument backed by an asset or defined group of assets. These can be assets such as real property, equipment, revenue streams, such as receivables, ownership interests in other companies or ventures. Now, as with secured loans, if the borrower defaults on the obligation to pay principal and interest on the bonds, the bond investors can enforce against the collateral. Now, there are also transactions in which we generally refer to as asset-backed securities, which are financial instruments that are created by pooling together a group of assets, such as loans, receivables, and then issuing securities that are backed by these assets. The difference here are that with regular secured bonds, or that the debt service on the securities comes from the cash flows of the assets themselves, as opposed to being collateral to being forced upon should the corporate issuer not meet its payment obligations. So issuances of asset-backed securities are undertaken using securitization techniques. These sorts of transactions can become more attractive forms of deal execution when the market is less favorable for other capital markets financings, such as unsecured bonds and equity transactions. At its most basic, securitization is a form of financing that involves isolating cash flows by selling or signing the assets that generate the cash flows to a bankruptcy remote special purpose vehicle, so an SPV as we call it. The SPV uses the assets to collateralize and generate interest and principal payments payable to investors who invest in debt securities issued by the SPV. The initial payment by the SPV to the sponsor of the transaction is typically used as payment to that sponsor for the assignment or sale of the underlying assets. The general idea is that by isolating the cash flows from the credit risk of the entity ultimately responsible for them, so the sponsor in this case, a company can get more favorable financing terms. This can be evident through an uptick in credit ratings for securitization notes, rather than where the sponsor to issue debt using its own balance sheet. Any stream of receivables in theory can be used for purposes of a securitization, so long as the receivables flows can be modeled or valued in some way. There needs to be some level of predictability. It can be a pool of receivables, such as mortgages or auto loans, which can be a static pool, which is an identified group of assets that remain unchanged during the life of the transaction, or a dynamic pool, where the asset pool gets replenished during the life of the transaction. So certain loans get paid off and others are brought in to take their place. Securitization transactions can also be structured as future flow transactions, that is, securitizing payment obligations or assets that are generated after the date of the closing or the launch of the transaction. Just by way of example, some assets that have been successfully securitized in Brazil include contractual payments for the operation of drill ships. So these were payments made by Petrobras for the use of vessels in oil exploration and production. Oil royalties payable with respect to offshore oil production. This was done successfully by the state of Rio de Janeiro, where royalties allocated to that state were used to raise several $1 billion of funding for the state. Diversified payment rights, which is a future flows asset class, which involves securitizing payments, the payment orders from banks outside of Brazil to beneficiaries in Brazil, and those flows are captured offshore. A similar technology are credit card receivables, and these are payments within a credit card network, such as the Visa or MasterCard's networks. In some instances, there can be recourse to the company in question, but in securitization transactions, we typically limit the cash flows available for payment on the notes to those that are the securitized receivables. There's a benefit to having the assets outside of any potential bankruptcy estate of the company in question. These securitization transactions are obviously all examples of transactions are utilized to bring in investments into Brazil from foreign sources. In the context of these sorts of transactions, security over the collateral is of obviously great importance, given that the collateral is the basis for the repayment of the debt in question. And one final point to discuss briefly here is debt restructuring. So one context where the issues with respect to collateral can become of more increased importance is when companies are in need of debt restructuring in order to meet their various financial obligations. Something that is unfortunately fairly common in the current economic climate, particularly with a lot of companies in Brazil these days. Now, our firm's been involved in a number of debt restructurings and distressed debt scenarios where the debtor in question is located outside of Brazil, but it has either operations or assets in Brazil that were pledged in connection with the prior financing. In those cases, the international investors were particularly focused on how security over the Brazilian collateral is taken and how to enforce against that collateral. This involves security in more distressed debt scenarios, as well as once a particular debtor has filed for bankruptcy protection. Investors and creditors frequently ask for assistance and guidance from local counsel here in Brazil as to how to navigate enforcing against these assets in pre-bankruptcy scenarios, as well as once the debtor has filed for bankruptcy protection, be it in a court process or an out-of-court process. One common practice in the U.S., and which is becoming increasingly more prevalent in places like Brazil, involves forming creditor and bondholder committees, which negotiate with the issuer, the borrower parties, and other creditors in the event of a distressed debt scenario. These groups are typically made up of holders of some sizable portion of the outstanding debt, and they typically appoint their own financial and legal advisors to negotiate with the borrower entities. There are also distressed debt investors who take advantage of the fact that bonds can be freely traded to purchase bonds in order to participate in the restructuring negotiations in order to get a return out of them. These sorts of groups of investors are obviously, for good reason, focused on how to exercise remedies on collateral. In debt restructuring scenarios, it's not uncommon for the parties to consider adding additional collateral or security during the renegotiation process. This serves multiple purposes, such as providing lenders with increased protection and incentivizing creditors as well to agree to new terms with the debtors. The potential implications of adding collateral depend on the various factors, including the type and value of the assets, existing security interests, the dynamics of the negotiations between the debtor and the creditors. The collateral can enhance the creditor's position, providing for a more secure debt profile by the borrower as well. Obviously, there's a lot of complexities involved here, but including obtaining consents from existing lenders. In any event, these are a few of the scenarios and products I wanted to discuss today from the international perspective. And with that, I'd like to hand things over to Luiz for a Brazilian perspective. Let me stop sharing here.
Well, thank you very much, David, and thank you to all for this fantastic attendance today. I'll discuss some of a few of the issues that we selected in connection with the take of collateral over Brazilian assets, based mainly on the questions that we hear from clients, like David mentioned. It's a sort of frequently asked questions that I will try to address here. I will not project any slides because we prepared a text, a short article with the main topics that we'll be discussing here. It's in our website, but we will also send it across after this webinar to all participants. And the main question, well, David has already answered. The main question is whether at all a Brazilian company can secure or guarantee a debt of its shareholder, of a foreign company of the group, to secure a loan taken abroad outside of Brazil. The answer is yes. but there are some points to be observed. And the good news here is that in general, there is no need for governmental approval, as there has been in the past. It was necessary to obtain a previous approval from the Central Bank of Brazil for any granting of guarantees or security that could give rise to the remittance of money to abroad, and this is no longer necessary. And in general, there is no restrictions on the remittance of funds in the context of the enforcement of the guarantee. No foreign exchange control under current rules. And this is a very important point. However, in order for the company to guarantee a third-party obligation, it's important that the transaction is set up in such a way that it does not harm the company itself or minority shareholders, if there are any. In many cases, there are no minority shareholders. We are talking about a full owned subsidiary, but in some other cases there are, and we must think of them. Because otherwise the controlling shareholder could be held liable for abuse of power. But how to avoid this risk? This risk can be avoided if the guarantor itself, the Brazilian company, receives benefits from the guarantee, even if indirectly. It does not need to receive the money. We are talking about typically about a guarantee to a loan granted to a company abroad. But there must be at least an indirect advantaged benefit to the Brazilian company, like the one David mentioned. For example, the increase in the group's value as a whole, and therefore also the increase in the value of the Brazilian company as a subsidiary of the group, as a consequence of the investments made with the borrowed money. This could be an example of indirect benefits to the Brazilian company, thus avoiding the risk of abuse of power, allegation of abuse of power from the controlling shareholder in making the company to guarantee a third party's obligation. And then, in addition, the transaction must be approved by the proper corporate bodies. Typically, the approval of the shareholders is required by the company's organizational documents, not only the approval of the board of directors, like in other jurisdictions may be the case. That said, another important preliminary question is the choice of the type of security to be taken among the possible types, which are basically the pledge, the mortgage, and the fiduciary transfer of assets. The choice depends on several factors, but the main important are the degree of protection that is desired, the nature of the assets, and costs. And we will discuss very briefly each of them. In the terms of the degree of protection, we can say that the fiduciary security is typically more beneficial to the creditor. So if we are assisting the creditor, we will typically recommend to take the fiduciary security instead of the pledge or the mortgage. And this is because the fiduciary security transfers the ownership of the collateral to the creditor on a temporary basis as a security to the obligation. And so, therefore, first, the enforcement tends to be faster. Fast in Brazil is not always as fast as we would like, but but the enforcement of the fiduciary security tends to be faster than that of a pledge or mortgage. And then in an insolvency scenario, and this is the most important advantage, the fiduciary creditor is in a better position because in the case of recovery process, the creditor is not subject to the recovery plan, with a few exceptions that are in the Brazilian bankruptcy law. But as a general rule, the fiduciary creditor is not subject to the recovery plan. And in the case of the bankruptcy, the fiduciary creditor is the asset that has been given as security under a fiduciary agreement is not part of the bankruptcy estate. So the creditor can take possession of this and will not compete with other creditors. Where in the case of a pledge or a mortgage, the creditor will be a preferred creditor, but will compete with other creditors of the same rank. Another good news for foreign creditors is that the fiduciary transfer can also be constituted in favor of a foreign creditor. This has not always been so, because initially this type of guarantee of security was created by a law in 1965, and that was a law that regulated the Brazilian capital market. And so initially, case law has been formed in the sense that a foreign creditor could not benefit from this type of guarantee because it was not part of the Brazilian financial or capital market system. But this has lost relevance since 2002 with the Brazilian Civil Code, because the Brazilian Civil Code created a new type of guarantee called fiduciary ownership that is very similar to the fiduciary transfer of that law of 1965. But there is, in this case, there is no restriction as to the type of creditor. So it can be created also in favor of a foreign creditor, either financial institution or not. Any kind of creditor can benefit from this guarantee. And case law has already confirmed that. So it's very important that the agreement providing for the fiduciary guarantee makes proper reference to the Brazilian Civil Code when we have a foreign creditor, and is drafted so that it meets the requirements of the Civil Code. Looking at the nature of the assets, well, basic rule is that a pledge is for movable assets, mortgages for real estate property, and the fiduciary ownership of the Civil Code is the object of this type of guarantee security are non-fungible movable assets. This means assets that cannot be replaced by others of the same type, quality and quantity. So we must have this type of assets in order to use the fiduciary ownership of the Civil Code. But here there is something to be clarified. The question whether the asset is fungible or not depends largely on how it is described. So if it can be described in such a way to distinguish it from other, then we can use the fiduciary ownership, and if it's movable, of course. And I give you an example.
As in art, beauty is in the beholder.
Yeah. Yeah, exactly. And I'll give an example. Money is fungible, is the fungible good that exists. So, but credit rights arising from the money deposited in the account number 123 at Bank X, branch Y. These are non-fungible assets, so these credit rights can be the object of fiduciary ownership of the Civil Code. In addition to that, there is also a fiduciary transfer of real estate, which is provided for in another law, a law of 1997. This law regulates the Brazilian real estate financial system, SFI in Portuguese, but it was amended in 2001 in order to expressly provide that the fiduciary creditor does not need to be a Brazilian financial institution. So the fiduciary transfer of real estate can also be used in international financings to secure an obligation debt in favor of a foreign creditor. And it has, in comparison with the mortgage, it has the advantages that we mentioned before of not being subject to insolvency proceedings. Another important point to be considered are the costs. As you may know, if you have already worked with Brazil or in Brazil, most of our attendees are in Brazil. Costs may be high in Brazil in connection with the registration of the security, and the security must be registered in order to exist as a security in Brazil in a public registry, and costs may be high. This reality cannot be completely avoided, but it can be softened, let's say, depending on the type of security. And I'll give two examples only to illustrate how important it is to properly decide the type of security. The first example, the mortgage. The mortgage must be created by a public deed before a notary, except in the case of very low value properties, but these are not relevant normally in the context of an international transaction. So it means notary fees. But the fiduciary transfer of real property can be constituted by a private contract, because there is a specific rule in the law in this sense, thus avoiding notary fees, and the contract can also be written in English, which is easier to negotiate with foreign creditors. Then it must be translated in Portuguese for registration, but it can be signed in English, while the notary deed must be signed in Portuguese. Another example is the security over machinery and equipment used in industrial or rural activities. When you take pledge over these assets, this pledge, they call it industrial pledge or rural pledge, must be registered at a real estate registrar office where the assets are located. And if the assets are in different cities, we must register the contract in different cities, paying several times registry fees. But if we take fiduciary property over these assets, this rule of the real estate registrar office is valid only for pledge. If we take the fiduciary property, it will suffice to register the agreement in the registry of deeds and documents. And these registries are normally much less bureaucratic, and registration fees are normally much lower in comparison with real estate registrar offices. So this is another advantage of the fiduciary transfer, fiduciary ownership. Another question that we hear frequently is, what about catch-all clauses? Can I have a contract saying all assets of the company are pledged or given as security to secure any debt? Unfortunately, not, because in the Brazilian legal system, the security binds specific assets to specific debts. It's like in other civil law jurisdictions. But a consequence of this is that both the debt and the assets must be described in the contract. And here we may have an issue, a problem, because large international financings normally tends to have a long term and are frequently subject to renegotiations, as David mentioned, in order to change amount, interest rate, maturity, to extend maturity, to take new security. And all this requires new amendments to the Brazilian security, giving rise to new registration fees. This reality cannot be changed, but here it's important to find a balance when drafting the agreement. A balance in the sense the description must be as detailed as necessary to comply with the legal requirements for validity of the security, but as broad as possible to allow for future renegotiations with minimum amendments as long as possible. So there is something to be analyzed here when we are drafting the contracts. And what about the collateral agent? It's very common that the creditors are represented by a collateral agent, which is responsible for taking the security and enforcing it if necessary. It's possible in Brazil, but one important thing to remember is that in Brazil, the security must be given to the creditor and not to a third person. So we can use a collateral agent in a Brazilian transaction, but the documentation must provide the agent with powers to represent properly the creditors, because the creditors are the true holders of the security and not the agent. Two last words, as we are running out of time almost, but two last words. One is about multiple securities. Common that the same asset subject to more than one security in more than one jurisdiction. This is possible, but we must take care so that these multiple security are not contradictory among themselves or nullify each other. For example, if the asset has already been fiduciarily assigned in Brazil, it cannot be afterwards pledged in another jurisdiction because the security provider is no longer the owner of the asset. So this may sound obvious, but is a mistake that we may tend to incur if we do not think that when planning the security package.
That we see that very often, this mistake.
Yes.
Myself.
And the last word is about personal guarantee. Under Brazilian law, the security provider is not responsible for the part of the debt that exceeds the proceeds obtained with the sale of the collateral, unless the contract says it is responsible. So it's important to say it. And what I'm saying, in addition to providing security, the Brazilian subsidiary is frequently required to provide a personal guarantee, a fiança, to the debt. And then, of course, it's possible But one thing to remind is that the Brazilian conflict of law rules must be observed in order for the choice of law be valid in Brazil. And the basic rule is here is that the agreement must be signed or at least concluded in the country whose law is chosen to govern the agreement. That's the basic rule. If we say this agreement is subject to New York law, but everybody is in the Faria Lima and signs it, a Brazilian judge may say, no, this New York law is not valid. So we have to pay attention here when signing the agreements. Having said that, I invite Eduardo to add his valuable considerations.
As to it being valued, we will see to that. But my concern, in the first place, thank you all for being here. It's a pleasure to meet you. We are thankful for the attention. My basic interest here is to discuss in a more dynamic view. What has previously been described is not a 100% favorable situation for Brazil. We know Brazil needs capital. There are infrastructure gaps. There are huge productivity gaps that might be improved if more capital was available for industrial plants. The unhappy fact that is that mostly it is not. Due to several constraints, what we are used to do in Brazil is provide collateral to finance that's flowing abroad to the benefit of other countries, not to the benefit of Brazil. One element, and this there are good reasons for that. The external capital flows from Brazil comes mostly to the financial markets, capital markets, and it has a speculative nature. What I would like to present is ways to circumvent that. To start, we should recognize that one of the reasons, and that's the reason Mr. Maílson da Nóbrega was present here, of this deficit in capital flows, long-term capital flows, is the huge exchange, is a perceived exchange risk in relation to Brazil. If I'm a foreign lender and I lend a huge amount of money at a given exchange rate, foreign currency reais, and the real is devalued, I cannot have, even if the company I lend to is successful, even if the project I lend to is successful, I cannot have, and it's very possible that I don't have enough funds to remit the amounts abroad and repay the loan. It's an unacceptable risk. So the purpose of my presentation is to give some ideas that so that this exchange risk is surmounted and capital flows become easier. The first thing to know is the first kind of risk, and that's more important perhaps than collateral, because collateral is not actually sufficient to tackle the issue of exchange risk, because exchange risk may be so huge that it will swallow up any collateral. Then there are, when we talk exchange risk management, there is a triad of non-collateral, so not directly collateral solutions, or beyond collateral solutions, in spite of the fact that they may involve collateral. The first risk, and these solutions have to be matched to risk. The first risk is I'm a foreign lender. I place funds in Brazil, but these funds are lost or they are devalued before they are even used. How could I solve that? One way of solving that is making foreign deposits. Is the company project, the company that is taking the finance, making deposits in foreign currency, even after disbursement with Brazilian banks. This is not a rule, but it's possible. The recent resolution 277 of the Central Bank of Brazil provides several cases in which this can be done. Once they are placed, the funds that have been disbursed by lender are placed in Brazil in foreign currency. Even if in a deposit with a Brazilian loan, they are safe against exchange devaluation. In which cases this is possible? There are three main cases. First, when the party being financed, the taker of the credit, is a public company, a company controlled by the government, such as Petrobras, etc. If it's financed by an international economic organization, those international development banks, BID, or even a foreign government agency, that would qualify. I would consider a foreign sovereign funds to qualify to that in case it has lent to a Brazilian government-controlled entity. So these funds are welcome to appear. There is also a wide case of entities that develop energy products, implement and develop energy products. All those entities, that may be a power company, a energy distribution company, all those may freely make deposits in foreign currencies. With Brazilian banks, obviously, deposits in foreign currency outside Brazil are free to any company. There is no restriction to that. But these cases are cases in which a Brazilian bank can accept here in Brazil deposit foreign currency. And the third case are business holding rights of exploration and production of oil and natural gas. Oil and gas companies, they also may make these deposits. Formerly, they were restricted to amounts that were used for the decommissioning of oil wells. That's to say, the closing of oil wells in an environmentally friendly way. This is treated in a ANP, Agência Nacional do Petróleo Resolution 854. But now, with Resolution 277 from the Central Bank, it's much wider, the possibility of their opening of these companies opening foreign currency accounts. This is one thing, one way. The other way, the second way in which exchange protection can be given to large finance is through tariff protection strategies, tariff or price protection strategies. This has to do with the fact that once a project is built and the money that was brought in by the lender is used, then the sale of the production starts. When the sale of the production starts and the monies are received in Brazil, you can also use the same accounts that can be opened if you are one of these three business, government-controlled entities, energy implementation companies, energy companies, or oil and gas companies. You can still use accounts in non-Brazilian currency, in hard currency, to hold the amounts of tariffs you are receiving. This is another count of protection. But there is more that you can do, because even if you do that, there is still going to be a gap relating to future tariffs that you have not received already, and those might be devalued. So and moreover, there may still be a gap between the moment you completed the project and you start receiving each element of tariff. That would be still a very large period of time, especially in large infrastructure projects, that may run over a long period of year, in which the contractual value of tariffs or of the industrial output of a large plant might be devalued, so as to deprive foreign lenders of the amount of the possibility of realistically receiving back their loans, because the resulting reais, as good, as plentiful as it might be, would not be sufficient to pay in a devalued Brazilian currency scenario to purchase enough dollars to repay loans. What can be done to tackle this very important problem? One thing is it's a rule in Brazil that if I am a Brazilian business and I have a Brazilian purchaser of my products, of my energy outputs, I cannot index it at foreign currency. I have to use Brazilian currency. There might even be discussion whether a punishable crime would arise under under a law against popular economy, into the protection of popular economy. But then there are exceptions to this rule, in which indeed exchange indexation may be put in place. What would be these cases? All infrastructure operators can put in place these indexation clauses when they provide exporters with elements of energy with their outputs. Whatever it is, provided that the exporter, the purchaser that is an exporter, accepts. So if your purchaser is an exporter, no matter it's not using what you provide him, what you are selling to an export, to include in an exported product, you can index the change. Another hypothesis is if you are selling to someone that will include what you sell in an exported product and reselling, in this case, the inclusion in the exported product is necessary. You can also index it at foreign currency and link it to foreign currency, always provided the purchaser accepts. A further and a very interesting case is the possibility of having structured transactions to apply indexation. You might suppose none of those previous cases apply. You can still create a structure in which exchange indexation is possible. For instance, if you assign to your purchaser a part of the liability towards repaying the loan, even if the creditor doesn't accept that, you still remain liable. But if you make that assignment, you are just assigning, delegating an obligation. And this delegation of obligation agreement would that would correspond to the value of the merchandise or of the power you are selling, might be indexed, might follow hard currency indexation. There are other forms of structured transactions. For instance, selling all your outputs to an entity that you form outside Brazil that would then resell. As the entity would be outside Brazil, it would fall into a case in which foreign exchange indexation is acceptable. All those later alternatives, they solve the problem of lack of business receipts in foreign currency before the business receipts are paid out to you, because when they are, you could, as I said, try and place them in foreign deposit accounts, even with Brazilian banks. Obviously, there are issues that remain. First, will my customers accept, or can they if you are selling to retail, selling energy, for instance, you obviously will not be able to persuade your customers to accept foreign currency indexation. And even if they did or had no other option, your lender would not be much better off, because you would know that most customers would be unable to pay in case huge devaluation brought high increase in tariffs. But that not be your case if you are supplying, for instance, energy to a large company, to a large entity that may even be sponsoring the projects, or a large company for building a plant. A later idea that we might cover all these hypotheses, and I'm summing up to conclude, would be to form a fund to, in case of prices or tariffs, typically public tariffs, increase the public tariff to a fixed amount that would form a reserve fund. And this reserve fund would then be used to repay, to atone for an exchange devaluation, in case it happens. In case the exchange devaluation does not happen, the amounts in the exchange in the reserve funds would be returned to consumers in the way of future tariff reductions. So no one internally would be better off, and the project would become viable. These funds, Brazil has a regulation applying to funds. It's CVM resolution number 175. It enables several kinds of funds that, even in Brazilian currency, can apply in foreign funds or in forex derivatives, thus ensuring that the amount that has been reserved would be safe against exchange devaluation. That's it. I'd like to finalize it, this more perhaps upbeat participation, by showing you, if Priscilla would show that to us, a chart that sums up these these conclusions. The chart is here. I'll walk you through it. You see
it?
Yeah, that's it. Priscilla, could you perhaps, I'm not seeing the whole table. That may be a problem of configuration, but I'd like to see the whole image. Could you zoom it down?
Maybe you have to hide in the window that is in the left, in the right side with our faces. Or to move.
At any rate, what you see here is the main landmarks, milestones of a loan: disbursement, start of construction of whatever has been, the loan has been taken to build, end of construction, the moment after construction, a payment flow starts, because the plant built is bringing, is showing output and has entries, and finally low repayments. You have a strategy in which you can, between disbursement of the loan and end of construction, the amount that has been disbursed will be held in forex, may be held in forex accounts in Brazil, thus atoning for exchange risk. This is possible if you are a related business or official agency, a government-related business taking loan for an official agency, an energy product, or an oil and gas project. The same strategy you can again use once you start receiving tariffs until final loan repayment, because you will have cash to deposit in foreign exchange accounts with Brazilian banks. And you could still reinforce this strategy by using the reserve funds that may apply in invest in foreign currency that I mentioned as the last topic of the presentation. This would allow us leave out a large period of exchange devaluation risk that would start when construction ends, so say when money has been spent, or would go on until you start having tariffs flowing in that you could deposit in a foreign currency account. But then these periods could be solved, the exchange risk in this period could be solved by your using foreign exchange indexation of your contracts until the amounts are paid. This is possible for exporters when they, for infrastructure operations, when they are selling to exporters. This is possible for any sale of elements that are going to be included in a product to be subsequently exported, even energy, that's an element of a product. And it's also possible in case of structured solutions. Say if none of the cases before apply, you could see assign the foreign debt as take repayment, assigning part of your debt to the purchaser of your products, appoint or create or sponsor an external purchasing agent. These solutions are not a result, are not a panacea against all evils, but they may go a long way in reducing the exchange risk that recently prevents so much needed capital from coming into Brazil. With that, I would thank you for your attention.
Thank you, Eduardo. We have two questions here in our chat. The first is from Felipe Armstrong. Thank you, Felipe. Luiz, idealmente teríamos então a fiança complementando a alienação fiduciária. Yes, ideally we'll have the fiança, the personal guarantee, complementing the fiduciary transfer, fiduciary ownership. Existe racional ou padrão de mercado para o volume da dívida que precisa ser garantido pela alienação fiduciária? Yes, normally all the debt is secured by the fiduciary ownership. The problem is exactly that if the secured debt is greater than the value of the assets, then as for the rest, as for the remaining part, we have only the fiança. So if we don't have the fiança, the security provider would not be responsible for that part of the debt that exceeds the value of the asset. So that's the rationale to have both guarantees. And then the second question from anonymous participant relates to Eduardo's intervention. What are possible conditions that energy companies may make deposits in foreign currency in Brazil?
There are none. They must develop and implement energy projects. With that, there should be enough grounds for an account to be opened by any Brazilian bank. There is still some doubt about oil and gas companies because the text of regulation has been changed to require, in our view, that it's not restricted anymore to amounts that are required for the decommissioning of oil wells. So in relation to oil and gas companies, there is an article in Resolution 277 that creates additional obligations, additional requirements, but I don't think it's a general case. It applies, the best view is that it applies to that specific case, but oil and gas companies have a general authorization to open these foreign currency accounts with Brazilian banks.
In fact, the new foreign exchange law permits foreign exchange accounts in general, but subject to central bank regulation. And this regulation is still not, central bank still did not permit foreign exchange accounts in general, but only in certain cases. But oil and gas and electricity are among these cases, right?
We have, since the end of 2021, a new foreign currency, foreign exchange law for 10,286, from which the information that's conveyed here has been taken. It's a law that tends to make more liberal the foreign exchange regulation. What's a continuing path? Since the later 80s, this has been following a path of liberalization. There are emotional grounds even in which this path does not flow faster, and always a threat, a fear that has been with Brazil since the beginning of the 20th century, that we may run out of foreign currency to purchase badly needed foreign commodities as fertilizers, wheat, refined oil, and things like that. So that's the reason exchange controls still remain, but they are being relaxed.
So we have then only a message from Lucas. Thank you, Lucas, but it's not a question. So does anybody else have questions? If not, we only have to thank you again for this fantastic attendance.
And for being here and believing in what we say.
Thank you so much.
Thank you.
Thank you, and bye-bye.